mention one number short.
No, no, when you're leaving.
Oh.
We're on, excuse me.
Oh, that one,
Yeah,
two,
yeah.
three, four, you're right.
Yep. I'd like to welcome everybody to the October 7th, 2019 Bedford Township Board of Zoning Appeals. Call to order, and we would like to introduce the members.
Kyle Dersch, citizen at large.
Jake Lake, Vice Chair.
George Welling, Chairman.
Arvin Shah, alternate.
Tom Zebek, liaison from planning.
Jody Rector, Planning and Zoning.
Dennis Kohler, Building Inspector.
Phil Goldsmith, Township Attorney.
Karen Kincaid, Planning and Zoning.
Okay. Would you care to lead us in the Pledge of Allegiance? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Karen, would you please call the roll?
Mr. Dersch,
Aye.
Mr. Lake,
Here.
Mr. Shaw,
Aye.
Mr. Zebek,
Aye.
Mr. Welling.
Aye.
Mr. Steiner is excused, and Mr. Shaw is serving as his alternate.
Okay, the chair will entertain a motion to approve the agenda.
Make a motion, we approve the agenda.
Second.
All in favor?
Aye.
Now we're looking for a motion to approve the minutes of the last meeting of September 10th, 2019.
Make a motion to approve the minutes of the September 10th, 2019 meeting.
Support.
Okay, all in favor?
Aye.
Aye.
Okay, now we move into new business. 6.1. We're going to talk about Heather Leach, 8770 Burke Road in Temperance, requesting a 2.5-foot fence height variance to construct a 6-foot tall fence. Karen, would you like to give us the details?
Are we
Open
open the public?
I'll make a motion, we open the public hearing.
Okay, I usually do it that
Second.
way. All in favor?
Aye.
Now, Karen, would you like to?
Yes. Again, the applicant is Heather Litsky of 8720 Burke Drive. She is representing herself. The acreage is .54 acre, R3 single-family residential zone. The applicant is seeking a plus or minus 2.5-foot height variance to construct a 6-foot fence in the front yard. The property consists of .548 acre and is located on a corner lot on Burke Drive and Whitewood Drive. Due to the uniqueness of the location, the parcel has 3 front yards. Per section 419.12 fences, 2A, number 1, fences within a front yard shall not exceed 3.5 feet in height and shall be restricted to decorative fences. The applicant has submitted a letter stating she would like to install a 6-foot tall wood fence to provide privacy and a safe area for her dog. The applicant has stated she contacted the township to ensure she was complying with the rules and regulations before putting up a new fence and was advised due to a corner lot and having 3 front yards. The ordinance permits a fence of 3.5 feet in height in the front yard. The applicant requests you consider the variance to allow a 6-foot fence to provide a privacy and allow her to enjoy her backyard safely with her dog. At this time, no letters of objection have been received.
Thank you. Is the applicant here, or somebody representing the applicant? Come up, please. Need your name and address.
Heather Litsky, 8720 Burke Drive.
Okay. Was there anything you wanted to add to her explanation?
She said most of what I was going to say. I just want to say, in my neighborhood, it appears that a lot of people have dogs, which is very nice because it's pet friendly. However, it causes concern for me as being like one of the only houses not having a fenced-in yard. The safety of my own dog getting out, but then other dogs getting into my yard. After I learned that I had to appeal for this variance, I also considered an invisible fence, but again, that doesn't prevent any neighborhood dogs from being able to get into my yard. When I bought my house for the large lot, I was really excited about it, and neither the selling agent nor my buying agent mentioned anything that I could have any types of restrictions due to the corner lot. And again, I only learned about that, and my realtor knew that that was a requirement, that I had to have a fenced-in yard for my dog. I only learned about the restriction when the fencing company came out to give me an estimate, and then I proceeded to make sure that I would follow any types of township rules and regulations. Let's see. And then I've only lived in a house with a fenced-in yard, so I'm just concerned for the safety of my dog, as he's only known, to live in a fenced-in yard. So right now, I'm not able to enjoy my backyard. I just take him out on a leash to go to the bathroom and come inside. I have a few neighbors that it's a little concerning, because they have a neighbor across the street, they have like a pit bull mix that I saw him walking one day. And the dog seemed to be controlling him more than he was controlling the dog, and he was an older gentleman. So that was something that concerned me, that if I was outside with my dog at the same time, his dog could get loose and get into my yard. And then another house that faces my backyard, whenever I take my dog out to the bathroom, it jumps at the windows and scratches them, and I don't know how big the dog is. I've never seen it, but that's another dog that concerns me. So I just am appealing for the variance to protect my dog and to be able to enjoy my backyard.
Okay, is there anybody else here who wanted to speak on this matter in the public hearing? If not, Chair will entertain a motion to close the public hearing.
Make a motion to close the public hearing?
All in favor?
Aye.
Any other discussion amongst the board or questions for the applicant?
Sure. A couple of comments for the group and my thoughts here. We're dealing with a corner lot that's a little bit unique from most corner lots, in that there are essentially 3 front yards, no true backyard or ability to have any secure privacy. I don't know if you guys are seeing it that same way, but I see quite a bit of practical difficulty in that.
Mm-hmm. Anybody else? Would anybody like to make a motion?
I'd like to make a motion. My motion is that we approve the plus or minus 2.5-foot fence variance in a front yard at 8720 Burke and Temperance, and reason practical difficulty of being a corner lot, and in that a unique corner lot with 3 front yards, no true backyard or ability to secure privacy.
Support.
We have a motion in support. If nobody has anything else, I'll ask Karen to take the vote.
Mr. Lake?
Yes.
Mr. Zebek?
Yes.
Mr. Shaw?
yes,
Mr. Dersch?
Aye.
Mr. Welling?
Yes,
Motion carried.
thank you.
Thank you.
Okay, I'll introduce these and then you can, Item 2 is open a public hearing regarding Greg and Townsend's wanting to change the frontage variance on the parcel bear with me, 5802-011-036-00. Mr. Zybek?
I'm requesting from the board and the chair to recuse myself from this decision, since I installed flooring, and I installed flooring for Greg Townsend. And I don't want any improprieties to be thought.
Right.
So therefore, I would like to be removed from this discussion. And I will leave until you're done. Just don't forget about me and lock me in.
Crossed my mind immediately.
I knew it.
Mr. Goldsmith, do we actually need a motion to do this?
Technically, by Robert's Rules of Order, the body has to approve a request to recuse oneself. And in this case, I think it's a proper request, because it could be viewed as not particularly or specifically with this property, but there's pecuniary interest at stake, and therefore I think it's a proper request of Mr. Zebek.
Could that be considered his motion?
Sure, why not?
Oh, well, we need somebody to second that
I
anyway.
second.
Okay.
Thank you, Robert.
All in favor of him being recused?
Aye.
Okay.
Get out of here, you big lug.
All right,
Okay.
I'll return.
Next, I would like to have somebody open the public hearing regarding item 2 here.
So moved.
Shot.
Support.
Support. Okay, all in favor? Aye. And is there a representative of, okay. And before I have her read all of that, I wanted to mention to you that there's only 4 board members left here, but you still need 3 votes.
Okay,
Okay, is that okay with you?
fair enough.
Okay, Karen, would you give us the details?
Excuse me. Again, the applicant is Greg Townsend. He is representing himself. The variance location is a vacant parcel on Erie Road between Crab and Lewis, a 17-acre parcel agriculturally zoned. The applicant is seeking to split a 17-acre parcel with 925.74 feet of frontage on Erie Road into 4 separate parcels that will require variances on 3 of the 4 parcels. Parcel 1, no variance is required, maintaining 433.74 feet of frontage and 7.78 acres. Parcel 2 requires a 165-foot frontage variance and a 1.91 acre area variance. Parcel 3, a 165-foot frontage variance and a 1.91 acre area variance. Parcel 4, a 165-foot frontage variance and a 2.07 acre area variance. Per section 400, 1800 Schedule of Regulations, in an agricultural zoning district, a minimum of 330 feet of frontage and 5 acres is required for each resulting parcel. The applicant has indicated in the submitted letter, the subject parcel is no longer being farmed and has become a hardship for the family to maintain the property. The applicant has stated there are discussions with the farmer on the possibility of growing hay on the remaining 7.78 acre parcel and believes the resulting other 3 parcels will conform with the surrounding area. The master plan designates this area as agricultural preservation with the intent to preserve prime farmland for agricultural production with uses of farming, food production, livestock, greenhouses, orchards, forestry, and open spaces, and the character of farmland with limited residential development. It should be noted that a zoning district to accommodate the intended master plan designation has not yet been drafted, and that is for an Ag 1 and Ag 2 zoning district. However, proposed language was presented to the Planning Commission on August 28, 2019 for review and comments. Direction has been given by the Planning Commission to move forward with the ordinance amendment. The ordinance will be put in final format and the public hearing will be scheduled as the first step of the approval process. At this time, no letters or calls of objection have been received.
Mr. Townsend, do you have anything to add to what she said?
No, that pretty much covers that one very well.
Okay, being an open meeting, is there anybody else here that would care to approach the subject? Doesn't look like any. I'm looking for a motion to close the public hearing.
So moved.
Moved by Ahmad, second?
Support.
Support. All in favor?
Aye.
Okay. Okay, board, any questions? Okay.
I don't know if I have questions, just kind of kicking off some comments or
Sure.
some thoughts I have right now. Right now, I'm struggling with the practical difficulty of the split. One, obviously, Ag has a 330-foot frontage, 5 acres. We'd be creating 3 parcels that do not conform to current Ag zoning. The master plan also does not have a designation to create the agricultural estate either. It does not call for that, so it doesn't conform with the master plan either. What I do see are 4 lots that could maybe be 2 to 3. 3 would still be a stretch. It still wouldn't conform to the ag zoning, but I think 4 is a bit much. Just my initial thoughts.
My question is, first of all, there's no homes or anything on the property now, and what exactly is the practical difficulty maintaining the property?
Well, previously, it always been farmed, the center
Right,
part of it.
right.
Anyways, I've been cleaning up the outside since '02 when I bought it, all around the perimeter. I've been cleaning that up and mowing and weed whacking, maintaining that very well. But Tim Hayes had been farming it, but no longer going to be farming it. So I've wanted to build a house over there, and a good friend of mine that's lived here in Bedford their whole life would like to build a house over there, but, you know, we don't want to really be maintaining 5 acres either. So I know that in the near future, it's going to be changing, that you're only going to be required to have the 165, so we thought if we could get that put in now, that, you know, we could kind of get those 2 over there. And then my parents also talked about maybe building a home there. That's why I'm actually asking for the 3. Otherwise, I would only really be asking for just the 2 splits there. So, but it's just 17 acres, an awful lot to mow and maintain. And I don't know if you've gotten by there, but when I say hundreds of trees around the outside, I leave all the trees there. I don't want to take anything down. I'm trying to leave everything there and have it as natural as possible. So it's just a lot of work to maintain and keep it looking good.
I have a question for you. You are proposing to divide into 4 parts.
Correct.
What happens if you only do 3? You'll be very close to compliance. Not exactly, but very close.
Well, we would just like to do the 3 smaller parcels rather than 3 that are going to be bigger. And then by doing this way, we do still allow almost the 8 acres at the one end, which Dan Martin, who is the neighbor 2 houses over to the west, said he would like to maybe plant some hay, him and his son Charlie, maybe plant some hay there and keep that still so it is somewhat farmed as well. So, and we haven't worked out the details on that, but he just actually, when I asked him if he would sign the letter stating it was, you know, he didn't have any objections to me splitting, he said, yeah, in fact, if, you know, if you want to work something out, he said, work something out, we'll plant some hay down on the other end and it'd work out great for everybody, so. The other neighbor, Richard Bonowit, which is directly to the west of me, also signed a letter, which I have a copy of that here too, that he has no objections, but I just didn't get a chance to talk to anybody else, so I can give that to you, but just been too busy to get around and actually talk to anybody else, but.
This ordinance.
Because you do not really have a good practical difficulty, which is beyond your control. So if you do 3, you will meet 5 acre requirement, and your frontage will become close to 310 feet. So you are much more better than it is now. You know, we cannot justify any kind of practical difficulty, which you cannot control. Your difficulty is moving and maintaining. That is not really hard beyond your control.
It's not a problem of topography or anything like that.
No,
Yeah,
no,
it's-
nothing.
Right.
No, we just, you know, when we counted all the other parcels in that area, the residential is right there. It's 2 houses away to the one side and 1 parcel away to the other side. There's 160 parcels in that square mile area, and, you know, I think I put in that letter, there's like 13 or so that actually meet the big requirement. I mean, there is a ton of small parcels right in that area, and it would look very nice still to have the 3 acre parcels there and keep an 8 acre parcel. Myself and the other person that went there, they have no desire to take care of 5 acres. That's why they were trying to get it split. They wanted 2.5, and I said, well, we can't do that. It has to be 165 wide by the depth, which puts them a little over 3 acres, which they were still fine with, but it really would fit in, you know, very nice with all the other lots that are in that area. There's very few that are 330 wide by the proper depth, but
Anybody else? Go ahead.
More comments, I do empathize that, that it does become quite a conundrum to have to manage all of it, but I'm kind of in the same footprint I was before. It's just, it's tough to justify without a practical difficulty there. But like I said, I do empathize with the situation you're in. It is a lot to maintain, I
A
understand
whole
that.
lot to maintain.
Yeah, Mr. Goldsmith, you have any comments on this?
Yeah. I don't know if you've ever tried to take care of 5, but yeah.
I don't envy you.
Tell you what, yeah.
Go ahead.
The only, the only comment I have is that if the zoning ordinance amendment is adopted, what Mr. Townsend proposes to do will be allowed. There's really, I mean, to send him back and request a rezoning, what would he rezone it to other than residential? Because it's already zoned ag and you can build in an ag parcel. And I don't know what the board will do. If the board adopts the new proposed zoning amendment for ag, I was just discussing it with Karen very briefly, that whether you're in ag 1 or ag 2, you'll be able to build with 165 feet of frontage and 2.5 acres. Well, each one of these lots complies with that requirement, providing that that zoning ordinance amendment is adopted by the legislative body, which is the township board, and that at this point is speculation. I have to agree with Mr. Lake that there's no, at least recognizable to me, practical difficulty here as it might relate to the geography, the topography of the problem. What they propose to do is deviate from the current zoning, and that's why they're here requesting a variance. So the lots that surround this area, although I haven't researched it, I doubt that Karen's researched it, but I am going to presume on my 65 years of residency here in the township and over 30 years of being the township attorney, most of those are probably prior legal non-conforming lots. Most probably are. But it doesn't alter the fact that that's the way it is in that particular area. That's the way it looks, and that's the way it's used. So I don't think there's any argument regarding preservation of agriculture here. There's a lot of woodlot on this property, and some of the property can and probably will be used for some agricultural production on a small scale if Dan Martin is able to come to an agreement with Mr. Townsend. But so I said a lot, but I probably didn't give you much direction. Those are my thoughts, I guess.
That's okay. So will it be advisable to recommend applicant to come back and without paying extra fee?
I'm sorry?
Come back later when this agricultural AG1, AG2 is passed by the board.
Well, he wouldn't have to. He, by right, if the ordinance is adopted as it's been in the design phase, if it's adopted, he wouldn't have to, because he would
Then
be
he'll be in
able,
compliance.
he would be able, by right, it would be a principal permitted use in either an Ag 1 or an Ag 2 district, because what he has proposed to you would comply with what's been proposed in terms of a proposed ordinance amendment for an ag area. So he would comply, and I think that's probably why he proposed 165 feet and an acreage area in excess of 2.5 acres.
And then also the question would still remain whether or not it conforms with the master plan from 2015 as well. I think that's another piece.
Does anybody else have anything else?
Just
Yes, sir.
I'm thinking along the lines that, again, the practical difficulty I've not been sold on. Plus, if you're in a hurry to do this, if you can make it into 3 lots, I think you might have more success.
We're in no real hurry, other than the good friends of mine that want to build on it would like to get started as fast as they can. I'm obviously, I got to get our house sold, and a lot of things would happen before I'm going to start building over there, so But it's the only reason I applied now rather than wait to see if the new ordinance gets passed, is to try to help them out, so. Because, we know if it does pass, then what we're asking to do here will already conform with all the new requirements. So I could have just not paid the $275 and waited, but I wanted to try to help them out and
Understand that. Any other comments from the board? Any other questions for the applicant? Chair will entertain a motion.
Can make a motion. I'm going to make a motion that we do not approve, based on the fact that we cannot find a practical difficulty at this time. The other issues we see here, parcels do not conform, the splits do not conform with the current ag zoning. It does not meet the requirements, or not the requirements, but the vision of the master plan. I think those are my supporting comments.
Okay, we have a motion. Do we have support?
I'll second that.
Okay, do we have motion and support? Karen, would you take the roll?
Mr. Lake?
Yes.
Mr. Dersch?
Aye.
Mr. Shaw?
Aye.
Mr. Welling?
Aye.
Motion carried.
Although I can't guarantee when the ordinance amendment will come before the board, it has to go in front of the plan, it has to be, the drafting of it has to be completed. I think our planner is working on that. It's being reviewed, then it'll come before the planning commission for a public hearing, then go to county planning, and then go to the board for the board's consideration. So I'll stick my neck out and say it should, you should know within 6 months.
Good luck with that. Hopefully you're all in your favor, Greg.
thank you.
Okay, we're going to item 3. This has,
Should we get Tom?
We have to get Tom.
thank you. I was waiting for somebody to
Kyle, I shot along.
I wanted to go over that as long as I could. Tom who?
Yes, to stay in the bathroom.
Question is, where did he go?
Wait, something. you know. Especially with the marijuana law. Welcome back, Tom.
Thank you.
Okay, item 3. This has to do with the appeal of MS Associated Limited, which is Temperance Distilling, about property, who's losing it over here? 5802-036-046-10. I'm asking for a motion to open a public hearing.
So move.
Support.
All in favor?
Aye.
Thank you. Karen, please.
Again, the applicant is Temperance Distilling, 177 Reed Road, owner MS Associated Limited, out of Monclove, Ohio. It is an I-2 light industrial, located in the Banner Industrial Park. It is to allow a temporary structure. The applicant is seeking a variance to place a 49 by 42, or a 2,058 square foot temporary structure on the south side of the existing 57,750 square foot building. Per Section 400-1903.2, temporary accessory buildings and/or structures shall not be permitted of any size unless approved by the Board of Zoning Appeals prior to the placement and upon approval from the Board of Zoning Appeals. The applicant must secure a valid Bedford Township building permit. It should be noted, all construction on site has been conducted without review of the structure and without a valid building permit. For Section 400-2204.1.c, permitted temporary buildings and uses shall not exceed a period of 2 years in undeveloped sections of the township and for periods not to exceed 6 months in developed sections. Section 400-1903 does not address structure-to-structure setbacks in an industrial zoning district, as the building codes and fire codes govern the required setbacks between structures based on use and building materials. It should be noted the Board of Zoning Appeals does not have the authority to grant a variance from building and fire code requirements. The applicant has provided a letter of their intent, including immediately behind the application, included in your packet, stating they are experiencing growth at roughly 3 to 4 times that of their previous year's volume, which has caused significant constraints on their available space. It is further stated they are in early stages of planning an addition to the existing building, and the temporary structure would provide alleviation of the overcrowding until a permanent addition is constructed, and at which time the temporary structure would be deconstructed. The applicant has stated it is anticipated the building expansion would be completed in approximately 8 to 12 months, and the hope is to add approximately 45,000 square feet while adhering to all code requirements. It should be noted that at this time, a site plan has not been submitted for review and consideration for any permanent addition. Should the request be granted, the following variances are required. Allow a temporary structure conditioned upon, 1, meeting all requirements of the 2018 International Fire Code and the 2015 Michigan Building Code. 2, submitting an application and plan to all required reviewing departments and/or agencies for review and approval. 3, obtaining a valid building permit, and 4, removal of the temporary structure no later than 6 months after the building has been constructed and has had final building inspection, unless a variance is granted by the BZA to allow for a greater time period than 6 months.
Thank you, Karen. Is there an applicant here? Step up, please. And your name and address, please. Oh, wait till you get to the microphone. We're broadcasting to the world here.
My home address?
The world.
Whatever. You can use this, yeah.
Zachary Owen, Temperance Distilling, 177 Reed Road, Reed Drive.
Anything to add to what Karen's description?
No, she covered pretty much everything, but it is strictly a temporary structure. The location of this structure would be within the expansion that we are currently exploring. We have basically moved to the code review phase of that, so while a site plan has not been submitted yet, it is moving forward. We are looking to be somewhere in the neighborhood of 45,000 square feet, which would easily consume where that temporary structure is. So we're looking at an end date of between June and August for the completion of the expansion, which would be likely well within that 6-month time frame that we would have to remove that structure.
Being an open hearing, is there anybody in the audience that wants to speak to this? If not, I'm looking for a motion to close the hearing.
Make a motion to close the public hearing.
Support.
All in favor?
Aye.
First of all, I'm glad it's going that well. I love businesses that are succeeding and growing. Congratulations on that. Does the board have any questions?
Yeah, I have a question, only one question. You are putting this temporary structure so close. Why so close? It's open space in between anyway. You are not connecting.
There's an existing amount of pavement that was being unutilized. I believe the previous tenant had use of that. It was a pull-through dock, which has a wider stance than a normal driveway would. And that's why we chose that location and the size of the structure.
Yeah, I have a question for Dennis.
And give you some
Yeah,
answers.
how much distance required in between
Well,
two
The
to
building
make the
code,
fire prevention stuff?
the building code is kind of different. When it comes to unlimited buildings, it looks for 60-foot yards between buildings. That yard doesn't necessarily have to be on one property, it can be on the next, but it should be deeded and maintained. If he attaches it that close to the building, if it's the same type of construction and the same fire
Then you have to have
suppression within it, you're
sprinkler
just putting an
system.
addition to the building. So I was gonna let him submit for a building permit and tell me how he's protecting the building. So if he moves it farther away from the property, the building to building, then his exterior firewall ratings actually reduce, so that's actually, those were gonna be questions for him if
Then
you
the
approve
second
the
question
structure.
is where you are going to put permanent structure?
Where you pointed at?
This is temporary.
Correct.
Where you are going to put permanent structure?
So it would basically come straight out from the east wall and go about 110 feet down. It would then come roughly 300 feet over, and then come back up with a small alcove for existing construction, existing infrastructure that is exterior to the building.
So in that case, you have to remove this building
Correct,
temporary
correct,
when you put permanent.
yes,
For that time construction, you will not
right.
have any facility.
No, it's strictly temporary, only to allow us to move things in and out of it, to help our space constraints. We're currently in a movement back into full production for next year's season, and so it becomes an even more troubling thing because we're not there yet.
Go ahead, Jake.
So, okay, I'm trying to develop a practical difficulty here. We've got the exterior building that we're going to put, the temporary structure. With that temporary structure, what's going on inside the building that requires that? I mean, I don't want to get too far into your business as much as you can possibly answer, but I'm trying to understand, is there extra materials? Is it extra equipment? Is it more people? What's the necessity to have the exterior space?
All three.
Okay,
So we are bringing in materials, we're bringing in additional people, and bringing in additional equipment. Over the summer, we had as
Could
many,
you bring the mic up to your mouth, please? Thank you.
I thought she was-
over the summer, we had as many as 100 people per shift. So space became very limited. And to produce the amount of material that we were making, we then required that come into our facility. Being a food plant, obviously putting things outside without some kind of protection is not really an option for us. So, and then the additional equipment that we're building is to increase the capacity that we can produce the product.
So basically, what you're looking to do is you're creating additional capacity to make materials, et cetera, and you're running out of space essentially, and there's some safety constraints within the building.
That's correct.
Okay.
It's mostly a safety and capacity reason that we're trying to open this small amount of space just to give us kind of a floating area to move things in and out of as needed until the expansion is completed.
Any other questions or any other discussion from the board?
How many people you anticipate extra?
Because we're purchasing additional equipment, are probably looking at adding maybe another 20 to 30 people on top of that 100 amount. We're a seasonal business, and so we are currently in a smaller, a lower number, but that is actually ramping back up to our full capacity because our growth is expected to triple or quadruple next year. So we're trying to spread that time frame out longer than the 5 months that we really sell this particular item. So it's really trying to, number one, increase our business, increase jobs, but in order to do that, we need this additional space.
So I think what you're trying to do right now is take advantage of the opportunity to build ahead of your busy season essentially.
That is correct.
And you need additional space to store the materials or the finished goods.
That's correct. It will not be finished goods.
Okay,
We're a distillery, and so for the government, the federal government mandates that we're a bonded facility. This structure would be outside of that bond. The permanent expansion would be within the bond, but this would be mostly for packaging material to move out. Finished goods would then stay inside.
Yes.
this one's more for Karen though. In the description, you mentioned two different distinctions, developed and undeveloped. And one had a longer time frame before something permanent could be in place or had to be taken down versus the other. What's the distinction for this case?
This is a developed site, so I think it would fall under being developed.
The surrounding isn't developed, though. I mean, it's fields.
It's in an industrial park. So you have two different opinions.
Yeah, that's what because I'm thinking here, he's got a timeline of 6 months, which by April, May of next year, he's going to be cutting it close if he's to put a permanent structure and get rid of the temporary structure.
But I do believe the BZA would have the authority to extend the timeline on that.
To be honest with you, I think that 6-month time frame is probably enough, only because the site work that would be necessary for the structure that we're building is going to have to be done long before April or May approach. So I appreciate the distinction difference, but I don't know that it's going to be really necessary. We're not going to be able to re-driving bulldozers around it to prep the site. It's going to have moved by then.
Well, any other questions or
And,
comments?
Mr. Chairman,
Yes.
if necessary, the board would have the authority to grant an extension beyond the 6-month if they ran into construction problems, site plan approval problems, that sort of thing.
Yeah.
You'd be eligible for an extension.
This goes the way he wants it, I was gonna make that a friendly amendment anyway.
Yeah. And this is one of those hybrid matters or appeals that you, from time to time, deal with that doesn't require a practical difficulty showing, simply because under the accessory building section, which is part of your packet, 400.1903, the BZA is specifically given authority to authorize a temporary structure. So that doesn't necessarily have to be part of your motion, although I think based upon Mr. Lake's question and the applicant's response, I think if you needed a practical difficulty, one has essentially been provided for the record.
I think it would be good on the record too. Well, with that in mind, would anybody like to make a motion?
I'd like to make a motion, take a swag at it. All right. So I will recommend that we approve the temporary accessory building at MS Associated Limited, otherwise known as 177 Reed Road in Temperance, Michigan, to allow a 2,058 square foot exterior or building and temporary structure, accessory building, based on the constraints of space within the facility, the safety concerns of the folks inside to allow for additional storage area. Also, in that, we should make sure that meeting all the requirements of the 2018 International Fire Code, submit plan to all required reviewing departments and agencies for approval, valid building permit, and then removal of temporary structure no later than 6 months, but I think in certain cases, maybe we plus or minus depending upon approvals and also any weather constraints.
I'd like to add a friendly amendment, just, we didn't mention parcel number,
Partial,
5802-036-046-10.
accept.
So one more, we'll add the 2015 Michigan Building Code as well to that requirement.
Thank you, sir. I will amend.
Agree?
Yep.
Okay, that was your motion. Do we have somebody supporting it? I thought I heard something.
I'm not a voting member, but my question is would there be consideration to possibly grant that extension this evening so we don't have to come back?
I feel I kind of did that, but I said plus or minus 6 months on top of that, so just basically we'll say an extra 6 months, so give them a year.
Yeah.
Okay.
year.
How about a period of time of 6 months, but if necessary, not to exceed 1 year?
I like that. I'll use that.
I'll accept that.
Accept that, accept that.
Okay.
We got it straight now,
I
guys?
think we worked on it as a team.
Okay. Yes, that's where we are. In that case, would you take a roll?
I'm sorry, who supported it?
Tom?
Tom? Mr. Lake?
Yes.
Mr. Zebek?
Yes.
Mr. Shaw?
Yes,
Mr. Dersch?
Aye.
Mr. Welling?
Aye.
Motion carried.
Thank you very much.
Good. Glad to hear about your success, too. Really am. We come to public comment. You give your name and address for the record. Anybody has a comment, please come up to the podium. Seeing the lack of a rush of people, we'll close the public comment. And any board or staff comments? Karen, let's start with you.
Monday is the deadline for the November meeting, so we don't have anything at this time, but we have had some inquiries, so we'll let you know after noon on Monday.
Thank you. Mr. Goldsmith?
Nothing. Thank you, Mr. Chairman.
I have nothing.
I have nothing.
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 I'm good.
Nothing.
Well, let's have something, and that is simply it's time to adjourn. No objections. This meeting is adjourned.
There we go.